Welcome to Middle Class Matters, Business News in English from Dr CMA Alagesan, Securities Exchange Board of India, in its confirmatory order in respect of Mr. Subash Chandra, the Chairman, and Punit Goenka, the Managing Director, in the matter of ZEE Entertainment Enterprises Limited, Part 16, continued. 73. The facts and circumstances of the case demonstrate that there exists a prima facie case against the entities. Further, the tone and tenor of the interim order shows that the directions have been issued as an interim measure to enable smooth progress of the investigation in the matter. It is noted that the prima facie findings that entity number 2 is not only the beneficiary of the prima facie scheme employed in the matter, but is the only executive director in ZEE Limited and is the MD and CEO of ZEE Limited. Thus, he is involved in the day-to-day management of ZEE Limited and he exercises control over the affairs of ZEE Limited. It is also a matter of record that ZEE Limited has not taken any action against him for the lapses noted with respect to the liquidation of fixed deposit of INR 200 crore by Yes Bank. In spite of the resignation of two board members, non-independent director and independent director of ZEE Limited, citing the said lapses. Similar is the case of entity number 1, against whom also at the relevant time until date no action has been taken by ZEE Limited in spite of his LOC being the trigger for liquidation of fixed deposit of ZEE Limited by Yes Bank. The aforesaid circumstances show that the entities or individuals in accordance with whose advice, directions or instructions the management of ZEE Limited is accustomed to act. Therefore, on the one hand, there is the administrative authority influence that the entities have over ZEE Limited, and on the other hand lies the interest of the shareholders and investors in ZEE Limited, including adherence to the principles of corporate governance norms, which is essential for the integrity of the securities market. In the given facts and circumstances of the case, the scales are tilted in favor of shareholders and investors in ZEE Limited and the overall development of the securities market rather than the entities. Seen in the aforesaid light, the interim measures taken while interim order is only preventive in nature. 74. It has been noted from the prima facie findings of the interim order that the entities have not been transparent in their dealings with either ZEE Limited or with the securities market. Entity number 1 had issued a LOC to Yes Bank without informing the board of management of ZEE Limited. It was also not informed to the market participants via a corporate announcement. Further, the fixed deposit was liquidated by Yes Bank on July 24, 2019. The intimation for the same would have been provided to ZEE Limited from the letter of Yes Bank dated 11th October 2019. It is noted that Yes Bank had discussed with the leadership team of SL Group various possibilities, including appropriation of the fixed deposit for the dues of companies belonging to SL Group. Entities are an integral part of SL Group, and from the aforesaid circumstances, it can be inferred that they had the knowledge about the steps that may be taken by Yes Bank. Also, based on undisputed facts, it is noted that on September 18, 2019, the 7 associate entities had returned to ZEE Limited that it has come to their knowledge that proceeds in relation to a term deposit of ZEE Limited has been transferred to their current account and that they would be returning the said proceeds. Being MD and CEO, entity number 2 did not take any action on the information provided by the 7 borrower entities of either inquiring with Yes Bank till September 30, 2019, nor did he inform the board of directors till August 17, 2019 about the same. Consequently, no disclosures were made at that time regarding the giving of LOC to Yes Bank or regarding the liquidation of the fixed deposit of INR 200 crore by Yes Bank to the shareholders or to the market in general. The edifice of the Indian securities market is built on disclosure and transparency in the dealings of the listed companies and intermediaries in the interest of securities market. The aforesaid actions of the entities are against the basic tenets of the securities market and are certainly not in the interest of the investors and the integrities of the securities market. In other words, the mischief that SEBI is trying to address by the interim measures is that the ZEE Limited as a listed company should be strictly adhering to the principles of transparency and good corporate governance norms rather than being in prima facie violation of the same. Therefore, the interim measures taken in the interim order are preventive in nature as they seek to prevent obstructions in fair and transparent investigation. 75. I am of the opinion that in the given facts and circumstances of the matter, the measures which are interim in nature satisfy the test of preventive measures as the prima facie actions of the entities and their involvement or influence over the affairs of ZEE Limited subverts the interest of the shareholders and investors, including the integrity of the securities market. Therefore, I find that interim measures pending investigation serve the purpose of protecting and safeguarding the market and the interest of investors and hence cannot be said to be punitive in nature. Submissions with respect to interim measures being contrary to principles of Constitution of India and the doctrine of proportionality. 76. Having noted as above, I now proceed to deal with the arguments of the entities in respect of principles of constitutional law and doctrine of proportionality. 77. The entities have contended that the directions in the interim order have deprived them of their fundamental right to carry on business under Article 19(1)(g) of the Constitution of India 1950. 78. In this regard, it is noted that Article 19(1)(g) of the Constitution of India 1950 guarantees to all citizens the right to practice any profession or to carry on any occupation, trade, or business. However, at the same time, it is pertinent to mention that this freedom is not uncontrolled, as Clause 6 of Article 19 of the Constitution of India 1950 authorizes legislation which imposes reasonable restrictions on this right in the interest of general public. Here I would like to refer to the order of the Honorable High Court of Jurisdiction for Rajasthan at Jaipur in the matter of Mrs. Punit Mercantile Private Limited versus Union of India and others, decided on October 29, 2010. In the said matter, the Honorable High Court, while appreciating the whole scheme of SEBI Act, has inter alia held as follows. Perusal of aforesaid paras shows that SEBI Act is preeminently a social welfare legislation seeking to protect the interest of common men who are small investors. Looking to the object of the SEBI Act, provisions of section 11(4) and 11(b) of the SEBI Act imposes a reasonable restrictions in conformity to clause 6 of Article 19 of the Constitution of India. This is in larger interest of the investors and to achieve the objectives of SEBI Act. In the light of above said, we do not find that provisions of sections 11(4) and 11(b) of SEBI Act are violative of Articles 9(1)(g) of the Constitution of India. Accordingly, challenge to the constitutional validity of the above said provisions is not accepted. Thus, the provisions are held to be intra vires. 79. It is a matter of common knowledge that SEBI Act is a special act enacted by the Parliament, conferring on SEBI the duty to protect the interest of investors in securities and to promote the development of and to regulate the securities market by such measures as it thinks fit. In the present case, the interim order has been passed by SEBI in exercise of powers conferred upon it by law and towards fulfillment of the duties cast under the SEBI Act. In the interim order as well as in this order, the conduct of the entities has been found to be prima facie fraudulent. As noted above, a temporary restraint has been imposed on the entities which is aimed at preventing obstructions in fair and transparent investigations in the matter. In view of the above, I find that the restraint order against the entities is not in violation of Article 19(1)(g) of the Constitution of India 1950 as contended by them. 80. The entities have also argued that doctrine of proportionality is now well established in jurisprudence and is a recognized facet of Article 14 of the Constitution of India 1950, and the same has not been followed in the present case. In this regard, firstly, it is understood from the observations of Honorable SAT in the matter of Zenith Steel Pipes and Industries Limited versus SEBI that the doctrine of proportionality becomes applicable when punitive measures are taken against the aggrieved party. From the observations of Honorable SAT quoted by Entity 2 in his reply, the following is noted. In matters relating to punitive measures, the emphasis has shifted from the Wednesbury principle of unreasonable to one of proportionality. A disproportionate punitive measure which does not commensurate with the offence would be violative of Article 14 of the Constitution of India. 81. In the instant case, as has been elaborated in earlier paragraphs, the measures taken against the entities are preventive and not punitive. To retaliate, the interim order seeks to ensure that a fair and transparent investigation is conducted in respect of the financials of ZEE Limited so that the interest of public shareholders are not adversely affected. Secondly, without prejudice to the above, the directions are, in my view, proportionate to the purpose of ensuring an expeditious, fair and transparent investigation. I therefore find that there is no violation of doctrine of proportionality of Article 14 of the Constitution of India 1950. 82. Entities have submitted that it is well settled that a law that violates Article 21 of the Constitution of India 1950 must conform to the five-pronged test of proportionality in order to pass muster. The five prongs are 82.1. A legislative state aim. 82.2. A rational nexus between the rights infringing measures and the state aim. 82.3. The rights infringing measures should be the least restrictive measure open to the state to achieve its goals. 82.4. There should be a balance between the extent and severity of the infringement and the state aim. 82.5. There should be provided sufficient safeguards against the possibility of abuse of the rights infringing measures. 83.1. Now proceed to examine whether or not the directions issued in the interim order meet the set test. 83.1. Legislative state aim. I have dealt at length in preceding paragraphs as to how the actions of the entities, while being part of the management of ZEE Limited, have jeopardized the interest of the shareholders of ZEE Limited and have affected the integrity of the securities market, including the confidence of the investors. SEBI has been tasked with the primary duty of protecting the interest of investors and to promote the development of and to regulate the securities market. Thus, in the given facts and circumstances of the case, at this stage of the proceedings, as an interim measure, directions were issued against the entities in furtherance of the primary objective of SEBI. Please like the video, subscribe to the channel and share it to your friends and relatives who are investors in the securities market to make them aware of how the companies are operating in the securities market, how your interest will be affected by their behavior. Thanks for watching.